The Caribbean Court of Justice, Appellate Jurisdiction. On appeal from the Court of Appeal of Barbados, hearing of the appeal in the matter BBCR 2023-003 between Shawn Weekes and the state. The members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess, who is present virtually. Counsel, you may now enter your appearances.
If it pleases this honorable court, I'm Andrew Pilgrim, and I appear for the appellant in association with my learned friend, Mr. Marty Garnes.
Yes. Good morning, Counsel.
Morning, man.
Good morning, Your Honors. If it pleases this honorable court, I am Neville Watson, and I appear for the respondent in association with my learned friend, Mr. Romario Straker.
Yes, good morning. Counsel, as you could see, Mr. Burgess, through no fault of his own, is unable to be with us physically, but he's very much with us virtually, and is participating in
Your Honor, if it pleases the court, we would be grateful if we could begin with our ground 3 and 4 rather than in the numerical order that we filed. And whether the learned justices of appeal erred in law or in principle when they found that the intended appellant applicant did not suffer any prejudice as a result of the delay due to the learned trial judge's direction on the same. The well-known background, I think, to this matter is that this matter came to trial some 20 years after the event. While there was some talk about whether or not some of that delay could be attributed to the appellant or not, the record will reflect that he left Barbados at a time when no warrant was issued for his arrest or otherwise, and remained in the US approximately for 10 years, returned to Barbados, was arrested and charged with the offense, and remanded in custody to the prison.
just stick up in there.
Sorry.
Was he extradited, or was he deported, or did he voluntarily return to?
Returned in the custody of officers, but my understanding is that there was not a deportation order. But he was not being returned as a result of this matter at all. He was returned to Barbados after not being regular in the US and having some other complications with the immigration department. There's never been a suggestion, certainly by the state, that the state sought him out and had him brought home pursuant to any order of a court or to any proceedings in relation to this matter or any other matter in Barbados.
When was he charged with the offense?
Let's see if we get that exact date from you, Marty. It's approximately 10 years after, Your Honor, but we'll get the exact date for you.
He was only charged after he returned.
Yes, Your Honor.
He was charged in 2011 then?
Yes, Your Honor. Yes, Your Honor. And then
He was incarcerated.
he was incarcerated then and applied for bail. He applied for bail and then got bail in February of 2017, and that should be, can tell me what page that? At page 57 of your record, Your Honor, is where he was, is a reference to his being admitted to bail in February of 2017. And then, even then, the matter still didn't attract the attention of the authorities then for a further 3 years. And then this trial took place, which is the subject of this appeal.
So, sorry, go
Will
ahead.
you go ahead, please?
The trial began in 2014, 2015, 2016.
No, Your Honor, in 2020.
When did the PI begin?
I think that's the 2014 date, Your Honor.
So effectively, his proceedings began in 2014.
Yes, Your Honor.
And when was the PI completed?
I'm not certain that that date is going to be in our record, Your Honor.
Okay. Do you know when he was indicted?
We can confirm that date, Your Honor. The 21st of July, 2016, Your Honor.
He was indicted in 2016. And when did his trial begin?
Is it July 2020?
Someone says, my sister says 13 August 2020.
Is that so?
I think 8th of October 2020 is the start date of the trial. That's right. Got a page number.
But in
It should be at your page 66 of your record, Your Honor, for the date of the start of the trial.
And that says what? 8th of October.
Sorry, Your Honor.
What is that date?
The 20th of October 2020. Sorry, the 8th of October 2020.
Okay.
So whilst we're here, could we just also clarify the circumstances, not just under which he returned to Barbados, but the circumstances under which he left Barbados? You said something about that earlier, that when he left, he was not under charge or
No, Your Honor.
restraint of any kind.
He was not under any investigation. There was no indication to him on the record that he was being investigated for this matter.
Okay.
And he left Barbados on a flight through the regular channels through the airport.
But he took a rather circuitous route to the United States, did he not?
Your Honor, not for me to say that he went a circuitous route, but
Well, isn't that obvious? Because he went to St. Lucia first, and then to Canada, and then to the United States.
I believe he eventually wound up in the United States. Yes, Your Honor.
Yeah. And he left Barbados how soon after the incident for which he was charged?
I don't recall. Approximately a week after the incident.
Approximately a week, yeah. Okay, thanks.
Obliged, man.
Just to go back to that trial date, Mr. Pilgrim,
Yes, ma'am.
I see Justice Ryan, Justice of Appeal, in his decision says 13th August 2020 was the trial began, and the jury returned a verdict on the 16th of 2020. If that is the verdict, it doesn't appear that that would happen within a week. So it does, but your junior can check it while you move on if you
At
wish.
page 45, I see of the record, August 13th, 31st, October 5, 8, 9, 12, 13, 14, 15, 16, 2020. But anyhow, you can proceed.
Grateful, Your Honor. In any event, I think that our record seems to suggest that it started in October, the trial, but I think that may not be so germane in terms of the fact it's either late August or early October as to the starting date. The Court of Appeal, in any event, accepted and agreed that the delay was egregious in this matter. They made such a finding. And while they may not have gone through the details of the cases we perhaps would have wanted them to go through in terms of establishing that delay, it is clear from their position, what they state in their decision, that, and this is paragraph 3.5 of our arguments, which is 1979 of your bundle, that the delay was unacceptable for a society that has proper respect for the constitutional rights of a citizen who is guaranteed a fair hearing within a reasonable time, etc. But in their view, this delay was something that they could cure or could have been cured by the judge telling the jury of the significance of delay in terms of the effect it could have on the minds of witnesses and so on, which we accept that would be important if you do embark on a trial, but that there would have been some other larger issues that would have loomed in this trial. For example, the Court of Appeal, in dealing with the issue of resentencing the appellant, chose to give a discount based on the delay and based on the breach of his constitutional rights. So,
And you take objection to that?
only, Your Honor, to the extent that it answers one question. In other words, it acknowledges the delay as a fact and says, because of this delay, we're of the view that he should have some benefit in terms of being sentenced. But it never addresses the issue of what was the impact of the delay on his ability to present a defense and to have a fair trial. And we say that that is a far larger issue than the delay point. So much so that sometimes one can't help feeling you wish you had a case from the outset. And this is not to say that counsel was wrong or did things that were less than a high standard. But this is the type of case that some lawyers would bring a challenge for delay before you get started. Typically, in my chambers, I think my friends on the other side would bear me out, that when I see 10 years coming around, 11 years, certainly, I file something before the Supreme Court to ask those questions, setting out always not just the delay, but what are the consequences of that delay and the impact that it will have on the ability of the appellant to prove a case. In this case, it comes out only at the stage of the defense when the judge inquires of counsel, will you be calling witnesses? And counsel says, we wanted to call witnesses, but of the witnesses that we had in mind, those who are not deceased, one of them is now not master of his mind. So in circumstances that, in my humble view, these are issues that perhaps would have been better canvassed before a constitutional court, this comes up then at the start of the defense. And the challenge for the court then would have been, should there be a thorough inquiry into this? Should we examine this and make a determination? Should the court address its mind to whether or not this man can properly defend these allegations? So that the judge was not of the view that that was something that should happen, and move swiftly along into the defense, which effectively then was just a statement of the accused as he then was.
In fairness to the judge, though, counsel, I see in the judgment from the Court of Appeal the observation that there was no application by either party for a stay of the trial on the ground, that the inordinate delay between the incident and the trial caused prejudice to the appellant. I think there was full advertence to it by the Court of Appeal, and I think they gave credit to the trial judge for not being presented with any applications, any submission. As a matter of fact, 2 sentences on, the Court of Appeal says the trial judge indicated at this stage that he intended to give a direction on delay, saying that nobody suggested to him anything he should put in his direction regarding the delay. So the advertence to delay was obviously resounding, but as you say, somebody of your passion and skill and experience
You're too kind,
probably have
You're too
done
kind.
much more in relation to, as it were, drilling down into the prejudice that the delay could have caused. That did not take place here, and it may be regrettable, or it may be that in the circumstances, that is how counsel thought they should proceed. But I think it was dealt with.
Your Honor, the difficulty is that, humbly, the learned trial judge does not simply pass over it, because the issue then comes up a bit later, and he asks, he tells the jury essentially that this man doesn't have any witness. He don't want to call any witnesses, which I think is unfair in the context of him knowing and having been told by counsel, we do want to call witnesses, but we have been prejudiced. So that at page 417 of your record, the judge, in addressing the jury, is saying, I'll pick it up maybe from line 17. I think you heard a comment by defense counsel, though it's not evidence, that the witnesses he would have called are now either all dead or mostly dead. So those are factors that I don't know. It's really not evidence. But you are human beings, you cannot close your ears to things, so you have heard. It's not been asserted, however, that he wanted to call any of them if they were alive. But that's the exact opposite of what was stated. On the contrary, it was stated, he wants to call witnesses, but the dead. So the judge now is taking that away from the jury, that assertion by counsel, which is all we have, so to speak.
Sorry, where is that assertion by counsel?
Can you pick that one up for me? Essentially occurs at the start of the defense, and it's at page 303 of your record, Your Honor. It's a conversation between the court and counsel that begins around line 15 with the court saying, "Thank you, sir. Are you calling any witnesses?" Dr. Blackman on his behalf, "My lord, no, sir. No witnesses," says the court. Dr. Blackman, "No witnesses because I have been advised that the persons he would have called have all deceased except one who is in a vegetative state." All right, okay, thank you. Sit down. So then when he later characterizes it as, you heard what was said, but he didn't even want to call any witnesses. It's a significant derogation from what the true position was on the record. I mean, as I say, I wish it had been canvassed more hotly. But in any event, the question we're asking in ground four really is, aren't there certain circumstances in which a judge, listening to a case and hearing certain things, would not think, I need to investigate where we are? And it's something that's actually happening in our courts more and more now, because in order for the courts to avoid the multiplicity of constitutional motions, the trial court is inviting you. We have 8 courts sitting in criminal trial jurisdiction now. So they're inviting you to make your arguments on that point before we embark on trial.
Yeah, Mr. Pilgrim, the Court of Appeal notes what had happened, that exchange.
Yes, sir.
And the Court of Appeal said in any event, this is the trial judge going on in his summation, he is under no duty to call any evidence or to prove or disprove anything. And you must remember that. Doesn't that sort of give the balance to what he said?
No, he wants to put his side. He wants to put his side. One of the deceased is his brother, who was present in this event. This is, if he had the opportunity to give his side, it's a completely different set of circumstances to telling the jury, well, he don't have to prove anything. The point is, he had witnesses who he could call, who could prove things. But that didn't happen. And so the question from us is twofold. One, ought the judge to be making that inquiry of his own accord in certain circumstances? Is one way you could look at it. But having been told, we wanted to call these witnesses are unavailable to us 20 years on.
See, I have the problem I have, or one of the problems I have, is 20 years on, the delay is partly caused by the action of your client. So that I do understand the point he made to me earlier about the circumstances in which he left Barbados, but the truth of the matter is that for 11 years, the state seemed unable to have proceeded against him because he was absent from the state. The second point I have, the second difficulty I have with the implication of your submission, which was along the lines that the case ought to have been perhaps thrown out right at the beginning because, so much time had elapsed, is that...
Your Honor, not just for the time, but for the consequences of the time.
Is that, yes, I hear you, but is that the nature and quality of the evidence against your client was such that wouldn't you say it would have been very difficult for a judge, even if you had that hearing before the trial or preliminary to the start of the trial, to have dismissed the case? In other words, the judge would obviously need to consider the length of time which had elapsed and the prejudice, if any, caused to the accused. But also, the judge would need to consider the nature of the evidence and whether that was capable of being degraded because of the passage of time.
Yes, Your Honor.
And having looked at those factors and having looked at the evidence in this case, would you consider it unreasonable for the judge to have allowed the trial to go forward even after such a lapse in time?
Your Honor, it would be difficult to say that without having some content, having some inquiry be done. In other words, this case hinges essentially on the comments of one witness who doesn't see the event. So if you have other witnesses who are present throughout at the scene, I can't say that their evidence would not be sufficient to move a court in a particular direction. In other words, in this case, the case was not bolstered and buttressed by many other parts. It was one witness.
But this okay, the number is correct. We agree this is one central witness, but this is a witness of some substance. When you look at what she said, and not just comments, but evidence that she gave in court, that was pretty powerful evidence, would you not say?
Your Honor, it's difficult to balance one set of evidence and say, well, this is powerful because she identifies this man before, moments before and so on, and moments after, according to her. Although she seemed, in my humble view, to be moving away from what she had said in her statement to the magistrate's court in the preliminary inquiry and so on.
And this is a man that she knew from before he was a boy.
Yes, Your Honor.
Somebody she's very much familiar with and acquainted with. And she gave evidence that, well, as you were implying, but the evidence included the fact, he says, that he pointed the gun at her at some stage in the incident. That is something that's going to stick in the mind of the jury, of the finder of fact, is it not? It's not something that you can sort of, get rid of easily, even with the passage of time, is it?
Your Honor, as I say, it's quite difficult in the context of there being other people present, there being a scuffle between parties, several parties armed, some chasing some one way, chasing the other way. I am not of the view that that type of evidence is insurmountable in context that there has been no inquiry into its quality.
But I don't understand why you say there has been no inquiry into its quality. Isn't that evidence corroborated by the medical evidence?
I mean, that he was shot, Your Honor.
He was shot twice. At least there were 2 bullets that entered him.
Yes, Your Honor.
She said that she saw him crawling up the steps, I think holding his leg. The medical evidence corroborates that there was a non-fatal injury to his leg.
There's no disputing that he was shot, Your Honor.
No. I'm talking about the evidence so far as it corroborates what she said. She also said that the assailant was standing over him. He got shot in his buttocks. She knew the assailant. The gun that the ballistics experts identified as being the gun in question was found at the home of the person she identified as holding that gun. And all of these very powerful corroborative pieces of evidence.
Your Honor, there may be aspects of that may not seem so powerful if we consider that, for example, the brother would have lived at that house. In other words, there is no connection of that firearm to this man other than the fact that it is found at his home, but it's also the home of his brother, his home of other people who there's no attempt to link the firearm specifically to him by way of any other type of ballistics or...
What you're doing, Mr. Pilgrim, is atomizing the various pieces of evidence and examining each and looking at each as if you have to prove each beyond a reasonable doubt. Part of your ground is circumstantial evidence. We could deal with that a little later. But that is not how you deal with circumstantial evidence. You look at all the various strands, and even if one strand by itself might not be enough, when you put them all together, then that is what you assess. So yes, several people lived at this house, including one who apparently had been threatened by the deceased, apparently, or there was something between them. But nevertheless, the assailant that she saw lived in that house.
Yes, Your Honor.
So that is not irrelevant evidence.
I'm not suggesting it's irrelevant, Your Honor.
The fact that the doctor says what he said, that corroborates what she said about him having this injury to his leg, which was apparently non-fatal, before he was struck the fatal, he was shot. That is corroborated by the medical evidence.
Your Honor, for example, if he had been shot by someone else, you can't necessarily link the fact that he is limping afterwards to the appellant.
And you're doing what I'm saying that you can't or ought not to do when you deal with circumstantial evidence. You're looking at each and giving an explanation for each.
Your Honor,
But when you put all together, then her evidence becomes very potent, very cogent, and it is for the jury to say whether they believe her.
indeed, Your Honor, but I am answering these questions in a context that I am asking the question whether or not these other parties who could have been called would not have had an impact on those strands. So that's why I'm analyzing them individually. I'm not at this stage arguing whether circumstantial evidence can prove a case or not. I'm arguing whether, if at the stage of a trial, it comes to a judge's attention that there are witnesses who were capable of speaking about the event who are no longer available because 20 years have passed, whether that could or ought not, whether that ought not to be something that he would take into account before moving forward. And I'm saying that it would be difficult, in my humble view, even now, for us to look back and say, oh, there's no way that could have beat the circumstantial evidence, for example, because we have not heard, there hasn't been that inquiry.
That's fair enough, but see, delay, examining delay and the impact of delay and the remedy that you afford for delay is not a very straightforward thing. And as my brother was pointing out, here, 10, 11 years elapsed when this man was not in the jurisdiction.
Yes, Your Honor.
And you can't discount that. His PI commenced 3 years after he came back into the jurisdiction. He was charged. Immediately he came back into the jurisdiction. So when you examine delay, it is all well and good to say, well, I got tried 20 years after. That's not fair. But you have to look at the other side as well. When they charge him 3 years after he came back, that is not inordinately long, isn't it?
The indictment, so they charge him immediately on his return.
Exactly. They charge him immediately, exactly.
The question becomes whether the 10 years, for example, between his return and his trial is not similarly extensive delay.
Well, let's examine the 10 years. You said the PI commenced in 2014. That is 3 years after he returned. That is not inordinately long.
Isn't it?
He was indicted.
Isn't it, Your Honor? Isn't 3 years inordinately long to start
It
with?
is long, but it is not inordinately long.
I suppose there's long and there's long.
Well, exactly. Because you see,
I think in the Barbadian context, 3 years is not inordinately long.
Your Honor,
Hopefully that has changed or is changing.
Indeed.
I think it's changing significantly now, to be fair. But at the same time, my sense is that acceptance of 3 years as not being inordinate is going to keep us to some extent where we are. Because before court, they appeared before a court this week and they said, there's no reason for me to be getting on the way I'm getting on because my client has been on remand for 3 years and there's no file, which would have been the case here.
Yeah, you see, my point is that you have to weigh up the 3 years that he spent after his return before his PI commenced with, as my brother says, the cogency of the evidence against him, the fact that a life was taken, and to simply dismiss the fact that there needs to be some accountability for human life being taken. And, ignore that fact because the person spent 3 years and not gotten, not had his PI started. It's a weighing up exercise. You see, if you look at it another way, if a crime is committed in 2010, police are trying to solve it, they can't solve it, it goes cold, a murder, a very serious crime. And 15 years later, they get a breakthrough. And they are then able to apprehend and charge the person they think has done this crime. Is it for the person to say, well, 15 years has elapsed and some of my witnesses have died during that time, they can't get a fair trial and therefore you can't proceed?
Your Honor, I think it's a little bit different, and I would want the court to consider this from a perspective of the justice system is saying to Shawn Weekes, you've been away all this time now, you're back here now. Surely that case should be on the front burner. Surely. And then the PI lasts for 3 years. A further 3 years go ahead before nothing else happens. Surely this, in other words, in every DPP's office, presumably, there are a set of cases which need to be on the front burner. And I can't imagine that this one ought not to have been such a case. If you are saying that you have this strong case and this man has caused you this delay of 10 years, someone in that office has to be saying, this case has already suffered this 10 or 11 years. Let us get after it. And so then you add you take 10 years to get through it. Is that something that we can weigh up and say that it's not inordinate?
Okay, so let's to the chase a little bit. What is it you are suggesting should be done because of the delay? Because the Court of Appeal did give your client some relief
5 years.
on that account. You're saying that that is not enough.
In terms of the reduction of sentence?
Yes.
We're saying that
What's your suggestion? What you think should be done because of the delay?
essentially the judge's failure to do any inquiry affected the right to a fair trial. Therefore, there should have been a permanent stay.
So he ought not to have been tried.
Ought not to have been tried.
Okay.
To sink it in alternative arguments about whether she should get some more credit for the delay and so on, is to ignore what we want. One of the things we want coming out of this hearing is for judges to be sensitive to delay, and for judges to say, I'm not just going to pick up any case of any age and go ahead with it. I want to inquire into the status of this case and what the defense is saying about its position on the delay. We want some sort of inquiry by a trial judge who sees a case come before him that is 20 years old, as opposed to doing what this judge does, and the learned trial judge hears that witnesses are available and tells the jury he didn't want to call them. And the question for this court, humbly, one of the questions would be, as opposed to making an inquiry which we say on the face of it would obviously be required, the judge does something else. He says to the jury, this man doesn't have any witnesses. He don't want to call any witnesses, which is not what was said.
Mr. Gilbert.
Your Honor, I beg your pardon.
I'm sorry with that. Can you hear me?
Hearing you loud and clear, Your Honor.
Yeah, I was wondering whether there was any jurisprudence that supports the approach you would want this court to take. I applaud your willingness to challenge this court to into new waters, but we can't do so without proper legal authority. And what we would be helped by at this point in time is your helping us with the jurisprudence that supports your position.
Your Honor, we have filed a number of cases, Brooks and Johansson in particular. If the court looks at Brooks, ex parte Brooks, which I think is page 1315. And it's really a case that's looking at whether there's an abusive process, which is what essentially the counsel at the time would have been asking. And the fourth paragraph on that page states, Mr. Livesey submitted that it is clear that this discretionary power rests on the proposition that every court has sufficient power to prevent abuse of its process, and he suggested that the decided cases fall into two categories. Those in which the prosecutor can be said to have manipulated or misused the rules of procedure, and those in which there has been inordinate and inexcusable delay, which has actually prejudiced the defendant. Obviously, we're relying on this second limb. There's no suggestion whatsoever that the state in any way manipulated the process. But we are saying there is the extremely lengthy period of delay, one.
Sorry, it's page 1315 by our page? By our
1315 should be of your record, Your Honor.
Oh, XP Brooks.
And it's up on your screen.
Yes.
So ex parte Brooks.
Yes.
So that twofold test, that's what we're saying the learned trial judge in this case should have been looking at. You say, well, we have the extensive delay. What are you saying now is your problem with the delay? How is the delay impacted on you? And if he looks at that and examines those circumstances, we are saying he would have come to the conclusion that certainly it would have been fairly difficult for the defendant to mount a defense.
Mr. Pilgrim.
Yes, Your Honor.
This is a discretionary power which resides in the court, isn't it?
Absolutely discretionary.
And where the court exercises its discretion, how much room do we as an appellate court have?
I'm sorry, Your Honor, I lost the last part of what you said.
Yes, sorry. I'm wondering, given that this is a discretionary power, how much opportunity is there for this court to investigate the exercise of the discretion where the exercise of the discretion is not shown to be capricious or in breach of law as such?
I think the challenge is that if on the face of it, the delay is extensive, there's the need for inquiry. And that I think that the courts are suggesting that from the time you have that extensive delay, it's something that should be scrutinized so the court assures that it is not being abused. And then if you have circumstances put before you that specifically say, in addition to this delay, I have had the following problems, that the court ought then to inquire into it. At a bare minimum, we wish that perhaps the delay on its face ought to prompt inquiry by judges so that it is not ignored and doesn't become a problem.
What you are saying, Mr. Pilgrim, as I understand it, is that although the Court of Appeal said that the judge noted there was nobody made any application for a stay or said anything in relation to it, you are saying that the court of its own motive should, as you say, presumptively in the face of such a delay, have taken it onto itself to make the inquiry.
Essentially, Your Honor. Yes, Your Honor. And essentially, that's what they're doing now in practice.
I'm sorry, let me just correct an earlier misstatement that I made. I said earlier that 3 years delay is not inordinate in the context of Barbados. I was wrong in phrasing it. It is not unusual. It is, in fact, inordinate. So please, strike from the record any statement on my part that 3 years is not inordinate. It is. Yeah?
I'm obliged, Your Honor. I think it's a time for new normals.
Yeah, Mr. Pilgrim, I think the Needham declaration showed us what the new normal ought to be.
Yes, Your
And hopefully, in particular, the prosecution officers around the Caribbean are working towards that new normal. But I wanted to ask something a little differently. When Justice, my brother, Justice Burgess, asked about jurisprudence, I thought that you would take us in the direction where you just said the courts in Barbados are doing this now of its own motion. They are inquiring into the issue of delay. But do you have that kind of jurisprudence to show to us where there is a duty on the court? That's what I thought you were, that you said you would make 2 submissions and you made one. One was that the court or the judge, you asked the question to make an inquiry of his own accord in these circumstances. And I thought that was the jurisprudence you would show us.
So, Your Honor, in our ground 4, we canvass Culpeper and invite this court to find that there are certain circumstances that ought to put a court on notice.
But Culpeper does not say that the court had a duty of its own motion. So that's where we could take Culpeper and all those out because we've read those.
Yes, Your Honor.
But I wanted to, I think this is what Justice Burgess was asking. Does an appellate court go that far to say, in these circumstances, this judge ought to have made an inquiry, and not having done that, this is an unfair trial, unconstitutional, and therefore we strike the conviction? You're asking us to go quite a distance,
Your Honor,
a
yes.
bridge too far. That's what, so I really hope you could zero in on that. It would assist me greatly.
Your Honor, in Culpeper, the court says, you have their page, ma'am? Their page. Criminal, just for a moment, Millie.
That's all.
It's page 425 of Culpeper. At page 975 of your record, Your Honor, in paragraph just above the letter G, perhaps I'll read from a little above that to give a little more context and start just below D. It was argued on the appellant's behalf that even if the mere passage of time had not prejudiced him, he had suffered real prejudice as a result of the loss during the interval between committal and trial of the body. Samples, including particularly the semen found on the vaginal and anal swabs taken from the deceased and the pubic hair found on her body. The loss of these samples, it was said, deprived the appellant of an opportunity to establish his innocence, or at least throw doubt on his guilt, by showing that the semen and the hair did not match samples taken from him. Thus, although no one can now know what a comparison of those samples with samples taken from him would have shown, the possibility exists that the appellant has suffered inseparable prejudice. And we liken this to the circumstances in which you say you have competent witnesses who are available, who are on the scene to comment. And the court continues in these terms. This is a much more persuasive submission. The board would accept that if there is prolonged delay in bringing a defendant to trial, and if during that time evidence is lost, which would be crucial to determining the guilt or innocence of the defendant, particularly if the opportunity has not been taken to make investigations which could and should have been made, a defendant's right to a fair trial may have been infringed. Now, we are saying that if this trial had come on, for example, in 2015, these witnesses would have been alive and available. But it comes on a full 10 years later.
Mr. President, I hope you're not suggesting that you die 20 years after, not 10 years after or 5 years after. Can you calculate it like that?
It is very close to the similar question I wanted to ask, with the permission and approval of my brother, as to whether there is a cutoff point that you have in mind after which you say that the court ought to itself conduct an inquiry. What is the cutoff point?
Your Honor, the time periods that we have in mind that we've outlined in various conferences in the region as to when we would think delay is really running against the state.
Yes.
I imagine that if those timelines are clearly in breach, a judge ought to be saying to himself, this is a problem.
Sorry, I'm
Let me
asking
know.
you, sorry.
Because
I know you have limited time and you might want to go on to other points. So
Yes,
if I could
sir.
get more clearly from you, what is the cutoff point that you are proposing that the court should be activated by?
Your Honor, if a case comes before a judge after 7 years, how
7
many
years.
he ought to be thinking to himself, let me at least inquire into why this is so. One, and two, what is the impact this has on the ability of the defendant to defend himself?
So 7 years.
Yes, Your Honor, but I can't say that I'm the authority on these timelines.
No,
I
that's
think
not
that-
your opinion, and that's fine. Now, the cases you quoted to us, in any of those cases, was delay the basis for dismissal of the charge? One, and two, in any of those cases, to follow on the question of my sister, was the initiation of an investigation as to whether the delay was sufficient to dismiss the charge done by the court of its own motion?
I think delay was the key point in Johansson. That was the basis of the striking out.
Okay.
I can't. My recollections of the detail of Culpeper is that it was not that the court, essentially the court in Culpeper is saying there are certain circumstances that will prompt a court to look. They don't go as far as to say there is a duty, but maybe in our Caribbean context, there's a need for the duty.
Okay.
But certainly, in this case, we're a little bit more advanced than that because we have the delay, and then we have an indication on record from counsel for the defendant, this has hamstrung me. And that we say that certainly is sufficient to cause the inquiry. In other words, if this court is of the view, the court doesn't agree with me that.
But in that regard, sorry, the indication from counsel came during the trial, that's all.
Sorry, Your Honor?
The indication from counsel that they might wish to call witnesses who are not now available because of a lapse of time, that indication came during the trial.
Yes, Your Honor.
Did it not? Right. So it's very hard to lump that as a reason for the judge to have initiated an inquiry before the start of a trial.
But in other words, was it too late then to make that inquiry? Was there anything to prevent the judge at that stage from making inquiries into why this is the case? It may be that as I said, in a better
You're
way.
conflating two different things with respect, counsel, because you're saying that the primary duty you want to identify and have imposed on judges is that of making the inquiry where the trial comes on 7 years after, I assume, the incident, or is it the charge? I'm not quite sure which is the 7 years that you're putting forward.
I was
But in
thinking
any event, that is one thing, that you make the inquiry before the trial begins. The situation now you're talking about is having an inquiry in the middle of a trial where the judge has already heard, the evidence that is available put forward by the prosecution. And the defense is now saying, well, I could have called these witnesses but for the lapse of time. So I'm saying it's difficult for me to understand which is it that you're putting forward, whether the inquiry ought to be done at the initial stage
in an
or
ideal
after the
world,
prosecution has put forward its case.
in an ideal world, Your Honor, we're saying that the delay in this case certainly was sufficient to prompt an inquiry.
Okay.
Regardless of the source of that delay. The learned trial judge in this case ought to have considered that delay as a major issue before this trial started.
Of his own motion, notwithstanding the fact that at the beginning of the trial, there was no.
Absolutely, my lord. I think 20 years from the date of the incident
Yes.
ought to cast into the mind of any judicial officer that this is something that should be examined before we start.
I understand. I think
I can't imagine that this court would disagree with that. In the context, a 20-year-old case comes before you, the first thing you must say is that 20 years? Why is that, and how has this impacted the matter in his journey?
Yeah, but after he or she has heard in this case, the evidence of the prosecution in support of the charge, surely the judge must have some idea as to whether it is fair to continue with the trial. I would have thought.
The challenge with that position, Millard, is that it means you're saying, well, the Crown's case sounds good, so there's no point in me stopping this trial now, which is contrary to what I imagine ought to be operating in the mind of the judge. The judge ought to be saying to himself when the matter is raised, however late, oh shoot, I should have looked at this before. But now that it has been raised, I have to explore it.
Okay,
So my position, Your Honor, is that the 20 years in this case should have prompted the need for an inquiry from the outset. It did not.
But of the 20 years, 11 is explainable. Without,
Okay.
And those 11 years, there's a question mark as to the extent to which, if at all, they should be counted against the state, because the man simply was not in Barbados. So you keep saying 20 years, 20 years, 20 years. But the reality is that 11 of those 20 years, there is not an unreasonable explanation for the state not proceeding against him. And so really, you shouldn't be speaking so much about 20 years, but rather of 9 years.
Except, Your Honor, that in this in any context, regardless of who we offer that fault to, no judge can ignore that 20-year period, whoever's fault it is.
No. With respect. And this is the point I was making a little earlier. It's not simply a numbers game. It is also about what goes into the numbers.
I understand that, Your Honor, but I'm simply saying that in terms of answering the question, I'm simply saying that 20 years ought to prompt a judicial officer to consider it.
And my point is that even if that, we agree with you, 11 of those 20 years reduces the impact of that prompt.
Well, perhaps there would have been a thorough inquiry into the circumstances. The judge would have been able to ask questions like, how come no warrant issued for this man? How come nothing was done in the first 11 years? What were the circumstances of that? And the court would have had a full picture of the 11-year period, which it's very easy for us now to say, well, he wasn't there, he left on a plane, he went St. Lucia and he went Canada, therefore, it must be at him. The temptation is very easy to say that is the case. But what I'm saying is that on its face, 20 years would prompt a judge to think this is something I should look at.
Okay, you made that point. Your time is running fast.
So before we move on from this point, though, something which engages me, adversarial proceedings. Instead of placing so much of a burden on the judge to conduct an inquiry after some appropriate or inappropriate period has passed, is there not an obligation on counsel for the defendant, for the accused person, who knows the circumstances and who knows what possibly these witnesses could have said, and also knows what they could not and would not have said, to decide whether I will invoke a nuclear strike here and say, Judge, this trial cannot go on, because if this trial, if it had gone on in proper time, the brother Michael would have come and said that he is the one who did the shooting or something of that nature. So absent that sort of knowledge, phrase it differently, that sort of knowledge resides
in the bosom of
in the
counsel.
defense counsel, and it is perhaps in instances, or it may be an overreach on the part of the judge to be inquiring into things which it is not your business to know at this stage.
Your Honor, as I said, one can always feel like you would have liked to have had conduct to the matter from the outset. But even with that in mind, and coming even late in the day, we're saying it should have prompted an inquiry of
Yes,
some
but the question is,
should you put it on the judge? Right,
yeah, the degree of responsibility for the failure of that inquiry. Where
Your Honor, I think the other answer to that is this court, in reviewing it, will want to know that the rights of the accused were not infringed and that his trial was fair, and that the journey to get to that is the key, as opposed to
Right.
who is at fault.
And therefore, part of that consideration is if proceeding with the trial was going to be unfair to the accused, then the accused or his counsel should have made that objection. That objection not having been made, it cannot be for the court to decide. Nonetheless, it would be unfair.
You need to move on to circumstantial evidence. But
For your
before you do, I just want to ask you one question.
Yes, Your Honor.
That is that, do you know whether statements were taken from the other persons who were clearly on the scene?
We're not aware that any of those people were in. As far as we know, none of those people were interviewed.
I see. Okay.
You describe it as bare bones police investigation.
I think that's the term. That's the term we use. There's a feeling in Barbados that when witnesses for the defense present themselves to the police station, they may not be well received. They may not be welcomed with open arms.
Yeah, that's very unfortunate. That's anyhow. Tell us quickly, what is your essential submission about circumstantial evidence?
Well, essentially, we rely on an event on our written submissions. I think the court will hopefully agree with us that there were two principal facts, we say, that would have required scrutiny by the learned trial judge, and it would have been useful for him to have given the direction that the Court of Appeal relied on in Ince, where they were saying that you must look at these two particular facts, analyze them in a particular way, and be certain that they should be the bulwark of the case, and that you can have proof beyond a reasonable doubt of those individual facts, as opposed to when there's a large number of circumstantial facts, circumstantial evidence, a large quantity of circumstantial evidence, and you give a general direction.
What I wasn't clear on is, how was your client prejudiced by the absence of that full direction on circumstantial evidence?
In our humble submission, Your Honor, those facts maybe deserve some more scrutiny in terms of the jury analyzing the full circumstances of this witness, who is given her evidence, as we all agree, some many years after the fact. And when the judge says that the prosecution don't have to prove all the facts in the case, they only have to prove the elements of the crime. It's our submission that he should have gone on and said that what is essential is the analysis of what we say are these intermediate facts, which we say are crucial to their case, without which they have no case.
Sorry, you want to remind us of those two intermediary facts?
Essentially, very good.
This is Miss Craig's evidence?
Well, it's essentially, sorry, Your Honor.
Miss Craig's evidence?
Miss Craig's evidence,
Yeah.
and her saying that she comes to the window and she sees him,
Right.
and this is when he turns with the firearm in her direction. She then goes back to plaiting the hair of her daughter, and then comes back
Is
after.
that a euphemism that he turned with the firearm in her direction? He pointed the gun at her. I think that's what her evidence was.
That's what she said, yes, sir. They're at page 1977 of your record.
Yeah. So you're saying he should have emphasized that the pointing of the gun at the witness, that was an intermediary fact, which was not direct evidence of the commission of the crime, obviously.
Yes, sir.
That was one thing that he should. And the other one was the colloquialism of the Bajan looking through the window. Is that?
Sorry, Your Honor.
I think the judge used the colloquialism of the Barbadian looking through the window this time when it's coming up. That's the other intermediate fact that he ought to have pressed on the jury. Again, not direct evidence of
the killings, and then the hearing of the shots thereafter.
Right. Okay.
So those two, we say, required specific analysis.
Okay.
In detail.
The photographs which were produced,
Sorry, Your Honor.
the photographs which were produced the architecture of the house and the shop, the door, sorry, there were two doors, there was a window through which she looked, etc., even after she closed the door, etc. Just that if the photographs are available, then I would ask that copies be left with our registrar.
We had requested them. I'm sure the state may have, but we have never seen them. In the appellate phase, they haven't formed any part of. But I'm sure that they exist. The state may have.
Counsel, if I may.
Oh, certainly, certainly. Your Honor.
How could you not?
Please, counsel. Sorry.
Daniel, go ahead, Justice Burgess.
Yeah, thank you, if I may. Again, I feel grateful to you for attempting to push us to develop our jurisprudence on the question of intermediate facts. You are attempting to argue the case of Shepherd and the judgment of Justice Dawson. But it seems to me that Justice Dawson, and you can correct me if I'm wrong, is envisioning a situation where the Court of Appeal pointed to that the direction should not be given in any event where it would be unnecessary or confusing to do so. And the Justice Dawson goes on to say it will generally be sufficient to tell the jury that the guilt of the accused must be established beyond reasonable doubt. And where it is helpful to do so, to tell them that they must entertain such doubt, a doubt where any other inference consistent and so on. This is what he's saying. Now, in moving this court or urging this court to move in the direction of the earlier Dawson direction or guidance, how do you reconcile that your position with the obvious discretion which Mr. Justice Dawson is speaking about? And if he is giving the trial judge a discretion to give a particular direction in respect of an intermediate fact or not, depending on the circumstances of the case, how do you square the circle, as it were? How do you insist on the first limb when this is attenuated by Mr. Justice Dawson, who said perhaps it's better to leave it to the general direction? Could you comment on that? Because I'm having a little difficulty in reading your written submissions. I had a little difficulty in understanding how you omitted to reconcile what you're saying with this part of Mr. Justice Dawson's judgment. So if you can help me.
It seems to us, Muller, that that Justice Dawson and the dicta in Shepherd seem to be identifying a situation in which you have two critical facts without which there would be no case. And in circumstances like that, it would be appropriate to give this direction. And he makes a reference as to links as opposed to strands, in which he's suggesting that the...
Yes, Counsel, that is in relation... Sorry, yes, Counsel, that's in relation to the point that you're attempting to, or the position you're attempting this court to move this court towards. But what I'm saying to you, Counsel, is that it appears to me that the paragraph which follows the first paragraph that adumbrates that general principle, that not general principle, but that principle which you want this court to commit itself to, this is attenuated seriously in the other paragraph where Mr. Justice Dawson ends by saying that you should really leave it to the general principle of proof beyond reasonable doubt.
The challenge I have with that as well, Your Honor, is that our Court of Appeal went on to use these directions and find them appropriate in Ince in Barbados. And then in this case, they say it's not appropriate because it might confuse the jury.
Doesn't it all depend on the circumstances, on the cogency of the evidence?
my concern, Your Honor, is that what is it about this case that would have made it so confusing?
It's not that it would have been confusing. It would have been unnecessary, and there is always a risk when you introduce unnecessary considerations, factors, etc., to a jury, that you are confusing them. We have seen, well, sorry, you have seen it time and again. The judge should not have gone on to do such and such because it could only confuse repeatedly.
But Your Honor, it is our position in these grounds, 1 and 2, that we should not make the assumption that the jury is not going to manage. If the appropriate direction is that where you have these 2 points and without these 2 points, the case fails, this is the type of direction we say should be applied. And that was what the court did our Court of Appeal did in Ince. And then they're saying in this case, they won't do it because it will confuse, or the possibility of confusion, but it is not clear from their judgment where they thought this confusion was going to arise.
Well, to my mind, it was manifest. Here is this lady which says that one moment this man comes and points a gun in her face, and then in another moment, however many minutes after, inside her shop, she hears the gunshots.
And there are only 2 of them.
And there are only 2 of them in the shop, and this man is found dead afterwards. So, watch me. That intermediate fact that she did not see him pull the trigger, she did not see the moment when the shots hit the victim, etc. That is intermediate. But in these circumstances, I mean, the intermediacy of it is really quite slender. Fact A, seen. Fact B, not seen. Fact C, seen. And the link between A, B, and C is so almost ineluctable that I don't know that any jury needed to be told, no, pay attention to this, and you need to consider whether the matter of her not having seen him pull the trigger, etc., is something that,
Your Honor, I don't want to stay too much longer on it, but I think it's sufficient for us to say that it is clear from the record that that was where the case would be won or lost,
right,
and it would not have been harmful to give the full direction that we complain of, and that Ince would have been
I'm going to give
the
you
authority for that.
another minutes in which you're going to tell us essentially why you think the sentence should be disturbed, assuming that you don't succeed on the other grounds.
Your Honor, I want to pass very quickly. I may get my numbers wrong, but we had canvassed the fact that the court ignored one of our grounds. And that ground was the one about the prevalence of firearm offenses and so on. I want this court to agree with me that the way that the Court of Appeal dealt with it, prevalence is no longer an issue.
right.
However, I want this court to be able to speak on the issue of prevalence when it comes time, not in terms of reducing the sentence. I just want to pass on that very quickly, because what happens is you get a case like Shawn Weekes in which, and this is the one thing I think we could all agree on, 20 years is relevant because you're saying this thing is prevalent in our society now, therefore I'm giving you more. I'm not saying that this is something that's going to affect Shawn Weekes now, because it doesn't. But I want very much for this court to deter judges from making increases in sentence where they do not have data before them that justifies that type of increase.
That, to my mind, counsel, need to be fully argued because, as we know, there are the variations in judicial approaches to this aspect. On one view, in our small society, everybody in Barbados, or in my case, everybody in Belize knows that the murder rate from firearm crime killings has skyrocketed. So, quote unquote, everybody knows. One national or 2 national television stations, they will broadcast basically every week night stories about some killings, etc. So in that society, There are things which everybody knows.
But Your Honor, I don't want to stay on it long, but I think that the danger is that we all feel this. So that both two taxi men spoke to us about it on our way here today. Two different ones, one to the Hyatt and one from the Hyatt here, right? Giving their own opinion about this thing, which I respect their opinions, but courts cannot function like that.
True.
Courts cannot say, man, this thing real bad, yeah. I'm going to stick 4 more years on you for this.
With respect, in certain circumstances, depending on what it is we are talking about, I think courts can say that. Courts have to be sensitive to the fact that a society is concerned about a particular thing. Courts need to impose sentences, which reflect the society's concerns and aggravation, apprehension about particular things. So it is not that we can only act on the basis of, as it were, scientific institutional knowledge of things. There are things which, as members of the society, which is why we are here at the CCJ and not at the Privy Council, we know about our societies.
Yes, Your Honor, but we still have to know based on not our feeling, having read the Nation newspaper or seen what is in Newsday. It has to be based on a knowledge, especially where you have this tremendous delay. Because if you have this delay, you may be sentencing a man today because of the trends, not of when he committed the crime 20 years before, but for what is happening now. And we're just saying...
I would want to see it argued properly in a full case.
I'm hoping that my friend will be here to argue it in July in more detail.
Order.
But there's a matter set already in which I think he will be part of a team that will look at it in more detail, and hopefully we'll have more time for it.
Bonds and all of that will be...
All right. But the simple point is...
We are familiar.
The law is being, in my humble view, very clear that we all have that perception. It's like when you leave school, you feel like somebody in Barbados left UE and felt that UE went to the dogs after he left. That's his perception. We prefer these things to be based on research. Put some data there and say, in 1975, this is how many there were. In 1985, this is how the trends have developed. In those circumstances, I find that there is prevalence. Therefore, I give this. And I think there's nothing wrong with that. But I think there is something wrong with saying, cheese on bread, man. Ain't going up. You're going to have to pay for that. Without saying, Shawn Weekes, you are part of a trend in Barbados. You are one of the persons who is doing this in the year 2000, as opposed to being affected the fact that there's a lot of crime around crop over at the time when you're dealing with a matter.
I got you.
Great for you, Your Honor.
Yeah.
So that, Your Honor, I think it is best to look at our ground, which addresses...
Mr. Pilgrim,
Sorry, Your Honor.
I know we have delayed you considerably. How much?
5 minutes, sir?
5 minutes?
Yes, Your Honor.
Okay.
I'm obliged. I know my friends are chomping at the bit. Unlike us, they didn't come on the red eye. You see, they have been waiting, laying in wait for us at the Hyatt, sleeping on cotton sheets with a 500 count, longing for the moment.
You're using up your 5 minutes, Mr. Pilgrim.
Sounds like a minute.
I think it's fine. Your Honor, essentially in our ground five, we look at whether the court ought to have set the starting point where they did. Essentially, they were embarking on a rehearing exercise, and they needed, in our humble view, to take into account all of the relevant features of the case in determining where their starting point should be. And in our skeleton arguments, we set out at 5-1 that they did not take into account a number of matters, including that no one else was injured in the incident, the firearm was recovered, there was an element of provocation from the deceased, and there was no pre-planning of the offense. And we are saying that those matters should have been taken into account by the court, and that in not taking them into account, the starting point that they did in fact use of 24 years was higher than it should have been.
We hear you on that, Mr. Pilgrim, but in the general scheme of things overall, if your client is convicted of the offense that he was convicted of, downgraded, I know, in the Court of Appeal, and he gets 9 years imprisonment, surely you can't quarrel with that, can you?
So by definition, we are quarreling with it, Your Honor. So,
You can't. I mean, you can't reasonably quarrel with that, can you?
Your Honor, we try to, as much as possible, make sentencing as scientific as possible so that we can point to the tariffs that we set in our guidelines to help us arrive at starting points so that this court would not be troubled by us too often. So that where we have these guidelines there, and these guideline cases specifically say, take into account these factors, and then the judge doesn't take them into account, it seems that people have a feeling that 9 should be good for him. And we prefer, if we apply the guidelines and these aggravating and mitigating circumstances that this court and others have given us to guide us, we will find ourselves in a better
Pilgrim,
position. Your
a
Honor.
client in the position of your client who gets 9 years for the offense for which he was committed, you can't quarrel with that reasonably, can you?
I'm here in your hands, Your Honor.
Fair enough. Thank you.
What do you think would have been a preferable starting point?
Perhaps 20 years. Your Honor. Give some credit for the 4 that we mentioned. You should give 1 for each.
You see, the point is that the guidelines are useful and they are, well, more than useful, as you know. You know, they help to harmonize sentences and so on.
Indeed, Your Honor.
But at the end of the day, surely the judge has to look at the crime for which the person was committed and identify an appropriate sentence, you know, so that we can't become slaves, I don't think, to the minutiae of or the details. And as you know, I'm myself very fond of the details and the formula and the various things that go into the formula. But at the end of the day, we have to look, I think, at the crime for which the conviction was secured and what the sentence was. And I'm sorry for pressing you, so I won't press you anymore, but it does seem to me that if we stuck with that correlation, looking at the sentence and linking that with the crime for which the person was convicted, you know, 9 years, it's not.
It feels all right, sir.
I don't, there were serious aggravating circumstances here which would
Yes, Your Honor.
potentially outweigh any of those mitigating factors that you mentioned. This man was lying on the ground, injured, when he was struck, when he was shot the fatal blow. Those are very, very serious aggravating circumstances.
There's no escaping the seriousness of this offense, Your Honor.
Yeah.
The trial judge had given him initially 28 years, less than 9.
Yes, Your Honor.
Yeah.
But
And then the Court of Appeal brought it down
my
to,
recollection, Your Honor, is that the sentence was life with eligibility for.
It's life. It was life.
Yes, Your Honor.
I made
It
sure.
is.
oh yeah, life, you're right.
I hope
life.
to argue this.
With a
point.
minimum of 28 years.
Yes, Your Honor. I hope to argue that point sooner rather than later, that there is no eligibility for anything in Barbados because we don't have a parole board. So the judges find themselves giving these sentences. I give you life, eligibility for parole after 2 years or after 100 years, after whatever, but there ain't nobody to decide when you're eligible. So the sentence to me is a nullity, but that's a whole different
Point, yeah.
That's another constitutional action on your part, Mr. Pilgrim.
Yes, Your Honor.
And that's a fair argument to be made. In these enlightened days, you really need to have a parole system. But that's for another time.
Indeed, sir.
Thank you, Mr.
I'm
Pilgrim.
obliged, Your Honor.
Yes.
I know my friends don't need to be too long, so they need chomp no more.
Mr. Watson.
Yes, good morning again, Your Honors.
Yes.
Writing on the last thing that my learned friend has said, I am hoping that I don't tarry too long, and I'm hoping that Your Honors do not hold me too long. But what I would want to say at the outset would be to just look at delay from my perspective, from the state's perspective. And in passing, I would want to say generally that delay is a subject that is bound to be around for a little while, unless something definitive happens. And I say this in the context of Barbados having few defense attorneys at law. In fact, few defense attorneys who take the cake, so to speak. Few defense attorneys that accused persons readily clamor for. I can perhaps count on the fingers of one hand. There are about 5. And then there may be 2 or 3 who are upcoming. My learned friend, Mr. Garns here, is one of the bright sparks that is upcoming. So when we have a case like in the trial court in which I am assigned, we primarily deal with gun-related matters, murders, etc., aggravated burglaries. And many of those cases have 3, 4, 5 accused persons. So this honorable court can very well understand that if we have 2 of those trials set back to back, they may very well take us into maybe 2 or 3 months at the minimum, with 4 defense attorneys taken up, sometimes maybe 5, because one person may be represented by 2 defense attorneys. So we already have the cadre of attorneys at law accounted for in that particular matter. So that when the other 7 courts are looking to bring on a matter, and those courts hear, well, Mr. Pilgrim is involved in this case. Obviously, Mr. Pilgrim cannot be there. And that is what has been happening for quite some time now. Because shortly after the 2-year or so delay that we had in Barbados for COVID, we were trying to get on track, trying to get on stream in relation to moving these cases out of the system. But that was not to be, because this problem occurred.
Was there a period of time during the height of the COVID epidemic when there were no criminal trials being held?
I didn't get the last part, Your Honor.
Was there a period of time during the height of the COVID epidemic when no criminal trials were being held?
Yes, Your Honor, there was a period of time, a sustained period of time. I believe subject to correction. It could have been about 18 months or just over 18 months.
But this was before, this trial commenced before COVID anyhow, in 2020, October 2020.
Caribbean Duchess, I think.
That was the height of COVID?
Yeah, COVID-19.
It's a,
20, yeah.
we started trials in somewhere around August. But then even then, the machinery was not running smoothly because COVID came back again and kind of truncated us, stopped us in some way from moving forward in earnest.
Yeah. Mr. Pilgrim says, amongst other things, that given the date of this matter, it should have been put on the front burner. And I have some sympathy for that. But I'm also sympathetic to the point which has been made, obviously, that part of the delay was not to be put to the responsibility of the state. How do you respond to that basic idea that because of the age of the matter, whatever the situation was, that this case ought to have been advanced somewhat over the others?
I take the point, Your Honor, that perhaps perhaps this case could have been maybe elevated above the others, but then one still has to give account, or one still has to take into account the availability of counsel, one, the availability of the accused man. I mean, he was in custody, fine. And one still has to take into account other matters which are in the system, which may be of equal vintage, or which may be of a vintage perhaps more than the 10 years, because I'm counting the 10 years when the appellant, was back in the jurisdiction. So I don't think then it's a one size fits all. I think it's a question of looking at all the variables that you have and then balancing up these variables to come to a pleasing conclusion. But I think that all in all, what would happen is that if other accused persons have been managed before the trial courts and they have had trial date set for them, then when their trial date has come on, and that goes ahead, it would mean that another trial would have to take the back seat. And then sometimes you find that counsel has another matter somewhere in some other court and can't get back to it. Like, case in point, we are presently setting trial dates for February and March next year.
So it's hard to jump the queue, you're saying?
It is difficult to jump the queue because then you would find another accused person saying, look, what about my rights? Why are you not doing my case? I want my case to be done first.
Okay.
Yeah, Mr. Watson, it is difficult for us to understand the other matters in the system. You made that point. What about the other matters in the system? There are other accused men. And I'd like to put this in, that there are other victims and families of victims waiting as well for justice. So that balancing, I think, is difficult for us to do without knowing what are those other matters in the system. But I wish to put a plug as well to say that sometimes we have regarded murder as the one that should go ahead. But we have a lot of victims of sexual offenses waiting in the queue as well. And they need their cases done. So it is a very difficult situation. I wonder, as we look at it here, what really could be done from the point of view of Barbados. Because if what Mr. Pilgrim says is right, and the question of delay, an inordinate delay, it has gripped the justice system in Barbados. We have to look and come up with something that can be done. But you go ahead with your points. I just needed to say that because we always prioritize murder above others. And I don't want that to be what the people would listening here would think that that's what we ought to do.
I quite agree, Your Honor, and it is a timely observance, a timely observation by Your Honor. These are matters, sexual offense matters are matters that are languishing in the system as well. Recently, I've had to deal with one that is about 15 years old. Oh. And the virtual complainant is still maintaining that she is interested in the prosecution of the matter, and quite rightly so. And especially when you look at the evidence on paper, the evidence on paper is particularly strong and particularly disturbing. So one cannot fault the state, the prosecution, or a trial judge, or even this virtual complainant for wanting to have their day in court. But one also understands that the accused man in the same matter would well, should want his day in court as well. It isn't always that. That isn't always the case. Oftentimes, and this is full and frank disclosure, oftentimes there is a system where accused persons find perhaps a little hole to crawl through, and they make that hole wider. And this is the context that I want to get to. They realize, look, my case cannot possibly go on today, or I will do something to frustrate my case going on today. I will come and say I don't have disclosure. I will come and say, look, the police haven't given me X or Y. I will come and say, my case has not been properly committed from the magistrate's court. Or I would say, look, I don't have a lawyer right now. I've changed my lawyer, or my mother is getting a lawyer for me. So there are so many variables at play. So many, perhaps too many to mention, Your Honors. And this is the stark reality in Barbados.
We get the picture. Now, so Mr. Pilgrim says, one, that the court should have held, the trial judge should have held an inquiry into the delay, given that the shooting took place in 2010 and the matter came before the trial judge in August 2020. What's your response to that?
My response to that, Your Honor, is simple. This appellant, if I am to draw from the but-for principle, the but-for, that is generally known in tort. If I'm to draw from that principle, but for this appellant's man's flight, which is always a potent force in looking at consciousness of guilt. This appellant's flight from Barbados to St. Lucia, to Canada, and then to the US, to my mind, put beyond tracing him, put that fact beyond tracing him in taking that route. And that is a reasonable inference that can be drawn. So it seems to me that he had no intention of being discovered or brought to justice. So, but for his flight, and but for his flight, no one knows, because it hasn't been said in the trial. No one knows. First things, when his brother died, that was not given in the trial.
Yeah, but those are things which, what Mr. Pilgrim is saying is that is precisely those things which needed to be inquired into.
But if we're supposed to follow the learning in Culpeper that my learned friend has relied on, then there's no duty on the trial judge to make that inquiry. And especially in this case where the trial judge had asked counsel if she was ready. When counsel indicated, where we indulgence.
What page?
Page? Where we indulgence, Your Honor? What page you have? Page 9? I'm advised here that we are, page 9, sir, and we are now on screen. We are on screen, sir, page 9 of the record.
That's our page 9. The CCJ is page 9.
Eight, 9. Yes, Your Honor. No, page 61. Page 61. I'm confused myself with the 2 pages. Page 61, sir, of the bundle.
Yes. Yes.
And Dr. Blackman, this is at line 10. Dr. Blackman, sir, if the prosecution is ready to proceed, I am also ready. I have what I need. So I submit, sir, that having heard that the trial judge was not really bound to extend himself into conducting any further inquiries, that statement is a potent statement that the defense was ready to proceed and that the defense had no complaints in relation to the start of the trial.
But I know that Mr. Pilgrim raised that later on in the trial, when the judge was told, I wanted to call these people, they're either dead or almost dead. Was there duty then? How do you see it, Mr. Watts?
I think, Your Honor, that context is everything, and that statement ought to be taken in conjunction with the trial as a whole. The evidence that the trial judge had heard or that had before him, that evidence, and that evidence, I submit, was rather cogent, it was potent, and it was very powerful evidence. And if we consider justice, Lady Justice is not only one side, it's a scale that we balance. And we look at, because contained in the code for crown prosecutors or state prosecutors, there's the question of public interest. And public interest is oftentimes a strong, compelling factor to proceed with a prosecution, considering, obviously, the evidential value of the case before the court. So,
Are you grounding the response that there was no duty on the judge to conduct the inquiry on the fact of what the defense said, that they're ready to proceed? Or I think my brother Barrow earlier had raised the issue of the adversarial nature of these proceedings. Are you basing it on something else? Because in another case where there is not this kind of response, I'm just wondering whether you think that there should be some kind of rule or some kind of principle, as was argued for, that in a case of a certain vintage, the judge ought, as a matter of principle, to conduct that inquiry.
perhaps the trial judge can, but that would depend on the overall circumstances. I don't think that it would automatically arise, but no doubt trial judges, and this trial judge in question, no doubt he was alive to the question of delay, because it is manifested much later on when the learned trial judge gave his extensive direction on delay.
Okay, right, thank you.
Your Honors, if there's nothing further on that, may I go on to the question of circumstantial evidence?
Yes.
I think that one must be careful in trespassing on the province of the jury to determine facts or to weigh up facts or even to assess the credibility of the fact giver. And trial judges must be careful in this regard. I readily stand by the learning in Shepherd to the extent that I depart from the whole giving of this direction on indispensable intermediate facts. I differ. I do not subscribe to that. I believe that all of the facts must be looked at in a whole and must not be dissected or must not be looked at piecemeal. And to do that might very well engender in the minds of the jury a sense that the trial judge is telling them what to do, how much weight to give to a particular fact, how much weight to give to a particular witness. When, as in this case, is my submission that there were a plethora of facts before the jury that they had to consider. And this is seen in the chronology of events of Miss Joanna Craig.
Speaking of which, I'd asked Mr. Pilgrim, and he does not have them. The matter of the photographs, do you have them?
No, Your Honor, No, Your Honor, I must have left them either on my desk or at home somewhere.
Okay, continue.
But, well, it is the appellant, I imagine, who prepared the record, and the appellant says that they either they don't have them or that they never saw them. But the records we have from other jurisdictions contain all the relevant evidence which was presented at the trial court. And these photographs are relevant evidence. And it's a little disappointing that they do not form part of the record.
Actually, if you look at the index to the record as filed, it identifies the pages where the photographs supposedly are. And it turns out that what is on those pages is, in fact, the tendering or the statement where the photographs are produced in evidence, but not the photographs. But anyway, you don't have them, let's move on.
Very well, Your Honor. Joanna Craig. What page? Yeah, page. You can pull it up. We're trying to pull it up on the screen, Your Honors. What page are we on? No, I had it marked. I'm sorry for moving a bit slow, Your Honors, but I'm just trying to pull it back up. I have the page marked. John Craig, right here we are.
Yes, that
Page
116.
116, sir. Sometimes when you're looking for something, it's right in front of you and you don't see it.
You see, you're operating on, not on our pages, but on pages that you got from the courts in Barbados. So there'll be a mismatch. But anyhow, go ahead.
Very well. So on page 116, and I would not read all your honors. I would just read salient parts of it in the expediency of time. I was in the house planning my little girl here, and she said she heard a commotion outside. And then, she goes on to page 117. She says that I saw he trying to crawl up top the step. And then we go on to page 118. And she says, so when I see he trying to crawl up to the top of the step, I see him feeling his foot. And she says, which mean a gun had, but I had to stop her. And then she says that he was trying to get into the top part. So, in essence, she follows the deceased man's path. She follows him into the shop part.
Visually, she follows him.
Visually. Thank you, Your Honor. And he goes into the shop part. So she goes back in, because he points the gun at her at some stage. And she, like a good citizen...
You said she goes back in? Who said she was out?
The window, she closes back the window. I'm so sorry, the bedroom parlor.
It seems to me that she said she closed the door.
The door.
Right.
The door.
But then there is, which is why I was asking about the photographs. It seems there was also a window.
There was also a window.
Right.
Right, there was also a window. And
There's a small detail as well, because sometimes there's a reference to her hearing a commotion and then looking through the door and seeing the deceased crawling up the stairs. But sometimes it's a reference to her hearing a shot. I'm not sure if I picked that up in the summing up or wherever. And then she opening the door, seeing the deceased crawling up the steps. So I'm a little uncertain as to whether, from what you're seeing here, it seemed as if she was speaking of a commotion. She heard a commotion. But in some other places, I seem to recall it being attributed to her that she heard a shot, to which she responded by visually following the deceased crawling up the stairs. Can you clarify?
yes, Your Honor.
Where you started, I think it was 116, it does refer to a commotion.
Right.
You're right. That's right.
I'm not seeing the part where they shot now, sir.
Neither am I.
Right. But
Pretty sure that in his summing up, the judge referred to her hearing a shot.
what is crucial, or what is important, Your Honors, is that this witness, Joanna Craig, is clear, crystal clear, that only the two persons were in the shop. So she is clear about that, and that is a fact that the jury is entitled to consider when they're coming to their conclusion.
You see, if we had the photographs, we could hopefully maybe see whether it was possible for somebody outside the shop to have shot him as he was crawling up the steps, if that was possible.
I quite agree, Your Honor. There is an exchange where she says that he, the appellant, was the only person who she saw with a gun on that afternoon.
The forensics didn't tell us, give us any estimate as to the distance between the shot being fired and its impact on the deceased.
No, Your Honor, Dr. David Gaskin did not give that evidence. His evidence was simply about the injury, the penetrating wounds, and the chart that the bullet took in the body of the deceased. Yes, so at page 164 of 549, page 164. She said, and this is that line 2, right at the top. I get up after I hear the shots. The first shot, I look outside. Then I went back and continued plotting the daughter here, as I see, when he point the gun. So she's putting the gun in his hand from very early. And then I come back in and I heard about 3 shots.
Okay, so, yeah.
So when I look out, I saw some men chasing Shawn Weekes. That is when I came out. A man was on the ground catching for his life. So that's what I see. And then the shop business, the shop part, where the 2 of them went and nobody else. So I think that the inferences were almost irresistible. The inferences were particularly strong, and a jury properly directed that they can look at those strands and weave them together to make a cable or to make a rope to sufficiently bind the accused man at the time. And that direction was indeed given by the learned trial judge. And that's the direction that Shepard adverts to if the judge doesn't give the direction on indispensable intermediate facts. And what is noticeable in Shepard as well is that Shepard says, if it is in the judge's view that he should give that direction. But Shepard does not say that the judge must give that direction on indispensable intermediate facts.
That's the point to which Justice Burgess was drawing attention earlier, I think.
Yes, Your Honor. So, Your Honors, I'm wondering if I've tarried long enough, or if Your Honors want me to say anything else in furtherance of my submissions, which I continue to stand by.
Well, you haven't said anything to us about the sentence.
About sentence. Go to the page of the sentence. I've highlighted it as well. I have it. Page, I want to refer, sir, to page 536 of the record. You got it. Your Honors, just to be clear, should I speak to the sentence in relation to the the aggravating factors of the offense that the trial judge found or sentenced in relation to the Court of Appeal of Barbados?
Well, so far as sentence is concerned, we are now concerned with whether the sentence imposed by the Court of Appeal was excessive. So I would like you to speak to that.
Oh, very well. My response is no, the sentence was not excessive. The sentence clearly took into account the aggravating factors. Even if we look at statutory aggravating factors that are almost a common motif running through murder throughout the region and maybe indeed across the world, we will find that the aggravating factors, callousness, brutality, depravity, violence, those are the kind of factors that are considered. And at page 33 of the record, the Court of Appeal was alive to the well-known case by now of Tiraf Prasad and the Queen. And this is at paragraph 72. And the court said, we consider the aggravated and mitigated factors of the offense. This was a brutal killing. And indeed, brutality is specified in the legislation. That is the statutory aggravating factor. With a firearm in a public place, potentially putting other persons at risk of harm. And that is a powerful aggravating factor as well that the Court of Appeal was alive to. And it is not the number of aggravating factors, but the rate of the aggravating factors, I dare submit, that the court would necessarily consider. And when it is weighed against any mitigating factors of the offense, and I did not find any personally, and the Court of Appeal did not find any either. And I think that, in my respectful view, that they were right not to find any.
What about the view of the appellant that the provocation was a factor that the Court of Appeal should have separately or distinctly considered? There is, of course, a view that provocation is what got him from out of murder into conviction for manslaughter. But there is the submission, and I simply want to hear you on it, that in addition to that reducing murder to manslaughter, it was a factor in sentencing that should have been separately considered. What's your view?
My view is that that would be to double count. When the guidelines in Elliston Graves and the Queen, when those guidelines were considered, the Court of Appeal found that they fell into a particular category, the 15 to 25. And when one looks at the aggravating factors, I don't think that we can, or that anybody can fault the Court of Appeal for so finding. This is, I want to say something, but I still don't want to say it.
Okay.
It's a dilemma.
We will not push you to go one way or the other.
I'll just be very, very brief with it. I think that the appellant was quite fortunate in having a sentence reduced from murder to manslaughter. And in retrospect, I really should have taken a certain course, but I did not, so I can't complain now. I did not. But, and I know that your honors are reading my mind, because I know your honors are adept at that. But
But we will draw attention to your submission where you were advocating for, even at this stage, life imprisonment.
Yes, Your Lordship, that was my view based on the evidence and based on the aggravated factors of the offense. And I still hold the view. I mean, it may be a view in it may be a view that can bear no fruit now.
All right.
Yeah, we have not pressed any.
A sense of your
Yeah.
disposition.
Very well. But I think that the sentence, sir, was right in principle. The sentence,
Sorry, right or not excessive?
pardon me, sir?
Sorry, did you say right or did you say not excessive?
Well, it was not excessive.
Okay.
It was not excessive. It was not excessive in principle. And we continue to rely on the case of Sumar Omar Smith. And page 1995, that's of the the respondents bundle.
How much weight do you give to, Mr. Watson, the age of the convicted person at the point at which the offense was committed? How much weight do you give to the evident turning around of his life from all of the things we have read, his achievements, academically and otherwise? And I just wondered, because I heard, I'm not trying to read your mind, but I heard the exchange with my brother just now, and I wondered if those were some of the things that went into consideration by the Court of Appeal, and which resulted in the sentence, which you say is not excessive. We also heard what you said about your own feeling about it, but I'm just wondering whether those kinds of factors may not have gone into some consideration by the Court of Appeal of the decision sentencing.
Surely they must have. And then when we look at paragraph 73, and that is that page, the same page we were on just now. Scroll down, thanks. At page 33, sir. Paragraph 73. The Court of Appeal says we now consider the aggravating and mitigating factors vis-a-vis the offender. We bear in mind that this was an immature young man of 17 years old with a previously clean record. He was assessed by the senior probation officers having a low risk of reoffending. So the pre-sentence report was very favorable in his regard. And by all accounts, during the period 2017 to the time of his trial in 2020, he showed himself to be an exemplary citizen. So that speaks to reform. That speaks to reform. Being gainfully employed in a small business in which he was regarded as a valuable asset. He has taken upon himself the responsibility of mentoring the young men, and that too will redound in his favor in terms of mitigating the sentence and bringing it down.
Mr. Watson just asking if prison rules in Barbados would allow him to get a reduction of his sentence for good behavior?
Yes,
Like in other places, a 1/3 or something?
Yes, Your Honor. At least 3 months remission. And so long as the prisoner, the appellant, so long as the appellant behaves himself in accordance with the rules of the prison, then they see no reason why they should withhold that from him.
So getting down to a phrase you understand very well, brass tacks. Getting down to brass tacks, he was given 9 years in 2021. So assuming remission, when would he be eligible for release?
That'd be 9 trees at 27. That'd be 27. So that'd be like take off 2 months, take off 2 years. 2027. 2027.
2027,
Yes,
which is like 3 years away, roughly.
Yes, sir. That's tomorrow, actually.
Yes, I hear you. Thanks.
I'm obliged, Your Honor.
Yeah, that's it?
Yes, Your Honor.
Yeah, okay, thank you very much.
Thank you too.
Can I ask, before you leave, Mr. Watson, without the parole system, if the court did order life imprisonment not to be released before X number of years, who would assess that? Does it come back before the judge?
That's a very good question. And I wish I knew the answer. But
Is that sentence a proper sentence in Barbados? Does the sentencing act, you have a sentencing act? Is there a provision for such a sentence?
there is a provision for life in prison under the Offenses Against the Person Act, Chapter 141, and Section 2 provides for that. It prescribes 3 penalties that a person can have, either death.
Yeah, but is there the provision in such a sentence not to be released before X number of years?
Or that's not written into the legislation.
But it was developed by a case law from this court, as I recall.
It was.
Does the role of the Privy Council become relevant here at all, or not?
If the role of the Privy Council?
Yes, the local Privy Council, or the Mercy, is it the Mercy Committee it's called?
Privy Council.
Or Privy Council, yes. Can they make decisions on the duration of incarceration of persons?
They should be able to. I think they're.
That's
I
falls-
think
that's surely
they had
falls
made
within
that
their remit.
pronouncement.
Yeah.
That surely falls within their remit.
I think they had made that pronouncement in.
But why I asked Mr. Watson is in paragraph 1 of the Court of Appeal judgment, Justice Ryan said he would be serving, leaving a term of 19 years to be served. That is under what the trial judge ordered, before becoming eligible for a release order from the superintendent of prisons. So is that how it works?
I honestly haven't looked at that. I would be guessing, and I don't like to guess.
Yes. I would propose that whomever, looks at the role of the Privy Council, because I'm pretty sure they have a role to play there.
To the extent that the way in which the sentence was expressed is proper, it could be an intimation to the Privy Council that they ought not to consider releasing him before that period of time.
Yeah, that's my understanding.
Yes, Your Honor.
Yes, thank you very much, Mr. Watson.
I'm obliged, Your Honor.
Yes. Mr. Pilgrim, is there anything that you wish to say?
Such arguments, just to raise it.
Yeah.
I'm a little bit concerned, Your Honors, because what I said about extradition, about his not being extradited, is based on my instructions from Shawn Weekes. But there's a conversation between him and the judge at page 58 in which he says he was extradited.
Yes, he said
So
it. I
and
saw
he
that.
mentions
He
it
said
2 or 3 times. So I
said
just want to put that on record. My understanding from what he was saying to me is that there was not a procedure in which the Barbados government sought him and he was returned. So I don't know if it's that he misunderstands or not, but I thought it's important for me to point that out. I didn't want that to leave.
Good of you. Yes.
Grateful, Your Honor. And briefly on the prison rules, I think it's important for this court to know, because I think it may have been canvassed before this court, maybe in Boyce and Joseph. Everyone gets the remission. So that the idea,
You behave really bad.
fellas up there behaving bad, doing what they like, beating people, beating prison officers, and still getting the remission. That's the honest truth. And I don't want the
Should be
court-
like that or not, it's another matter. Huh?
is another matter. But the real point is that that's a matter for the prison. That's not something that the judges involve themselves in any way. But I think I had canvassed the arguments in Romeo Hall about whether we should be looking at it in a particular way, and the dissenting judgment of Justice Witt was taking that into account. But the point is, and that was, I think we invited the state to say otherwise, everyone gets it regardless of their behavior.
But you see, if there's a parole act, I mean, so many countries in the region now have parole legislation, and it is surprising that Barbados does not.
The bill has been around for in excess of 10 years and been going back and forth. But as far as I'm aware, speaking subject to correction, as recently as February, the Minister for Home Affairs was referring to the fact that we are soon going to have it. But meanwhile, the learning trial judge, in this case in particular, is moving rapidly ahead with these sentences as if they exist, in spite of it being drawn to his attention. So it's something that we will need to address. Your Honor, I wanted to say very, very, very briefly about the idea of the sentencing, which won't affect this matter in terms of the prevalence, that all the learning is speaking towards the judge only using that if he has data, and only using it where it's something that he can take judicial notice of, and it being to a level of really being data that is provable and incontrovertible as opposed to his opinion. And the best way to find that learning is in the case of Spence, which we referred to.
In the case of
Spence.
Yeah.
That's 1767 of your record, Your Honors. That's all, Your Honors. I'm grateful to you.
Yes, thank you very much.
Thank you.
Well, we will take time for our decision, and we will let you know.
We're obliged, Your Honors.
Yes.